Unconstitutional. Then a 5-justice majority decided to do something different with this case. Rather than decide the case as they normally are supposed to do in the course of the term of the Supreme Court, which ends every June, July of every year, they held it over. They issued a notice in June, July of 2009 saying, we want new argument, re-argument in September, a rushed period, before even they were going to start the new term, which starts in October. We want new argument on the following questions. Whether the 2003 ruling, McConnell v. FEC, that upheld that very provision that was being challenged, whether that should be overturned. And more important, whether a 1990 ruling, known as Austin v. Michigan Chamber of Commerce, should also be overturned. And that ruling made clear that corporate political expenditures can be prohibited. The state of Michigan had barred corporate political expenditures in their elections, and the Supreme Court had upheld it. And here were these 5 justices inventing out of whole cloth an entirely different question for this case, whether to overturn that long-standing precedent. It was not argued in the trial court, was not part of the debate, did not get argued by the Citizens United attorneys in the spring of 2009, but here they were rushing this argument. And then surely they moved forward in January and issued their ruling, overturning that prior precedent and making clear that corporations are now free to spend their billions and billions of general treasury funds into our campaigns. We have set up a new campaign to challenge this ruling, the Free Speech for People campaign. And the Free Speech for People campaign is a coalition of public interest organizations, business leaders, democracy activists, and tens of thousands of people who have already signed up on our website, freespeechforpeople.org, in the wake of this ruling. We launched this moments after the court issued its ruling because we were aware that they were going to go over the cliff. And we have on the back table there handouts, more information about this ruling. I invite you to join us at this campaign. But the important thing to understand is that this ruling, the Citizens United v. FEC, is not in isolation. It, in fact, is the most extreme extension of a corporate rights doctrine under the First Amendment that has been advanced for the past 30 years. For the first 200 years of our nation's history, we never recognized corporations as people with free speech rights under the First Amendment. In fact, the framers recognized the danger of corporations in our society. James Madison spoke of corporations as a necessary evil, subject to proper limitations and guards. Thomas Jefferson said we must crush in its birth the aristocracy of money corporations. And for the first 2 centuries, the courts followed that framers' intent with respect to the First Amendment. And then in 1971, Lewis Powell came along, private attorney then for the U.S. Chamber of Commerce, writing a memorandum, infamously now known as the Powell Memorandum, in which he articulated how corporate America could use, in our view, misuse the First Amendment to strike down democratically enacted reforms in a host of areas: environmental, healthcare, consumer rights, civil rights, and yes, campaign finance. And Lewis Powell then became Justice Lewis Powell, nominated by then President Nixon to the Supreme Court, confirmed by the U.S. Senate. And he became an architect of this corporate rights doctrine under the First Amendment, in which he argued, along with other justices, that corporations are people with free speech rights. Now, to give you an example of how this erosion has occurred, we ought to look just at this one example out of Vermont in the 1990s. You know, Monsanto developed a drug that was known as the bovine growth hormone drug that increased milk production in cows. The problem is it was a very dangerous drug with serious human health effects and health effects on animals. And large parts of Europe and Australia and other parts of the world outright banned the use of Monsanto's drug. All Vermont sought to do was to label milk products coming from dairies where this Monsanto drug was being used, so that people could make a choice whether they wanted to buy the milk product with the drug being used, or whether they wanted to choose a different milk product. That's all Vermont sought to do. And the Industrial Dairy Association went after the state of Vermont with respect to this law. They sued the state in federal court on First Amendment grounds, applying the corporate rights doctrine, and they won. They got it struck down. So now we have turned the First Amendment on its head. It's no longer something that protects people and their right to speak or not to be forced by the government to say something. And now we've enabled corporations to hide critical information designed to protect human health. That is how wrong this doctrine is, and that is how antithetical it is to the basic intent of the First Amendment. But then we have this ruling, Citizens United v. FEC, which, as I say, is the most extreme extension of that ruling. And Justice Stevens, in his dissent, says it is a radical departure from settled First Amendment principle. And he's right. In the political arena, it is a radical departure. We need to respond as a people. We need to say that we the people, not we the corporations, govern. And the way to do that is via the constitutional amendment process. We need to say that the 5 justices of the Supreme Court do not have the final say on this. We the people have the final say. And there are instances in our nation's history where we as a people have stood up and responded to egregious rulings of the United States Supreme Court. Dred Scott sanctioning slavery. Plessy v. Ferguson sanctioning separate but equal. Bush v. Gore. Citizens United v. FEC. We as a people have to stand up on this one and respond. Now, I recognize that some here may say, well, that is a huge tall order to amend the Constitution. That's just impossible to do. Well, this is my response. We have done this before, 27 times before in our nation's history. You know, Doris Haddon, otherwise known as Granny D, recently passed away at the age of 100. She was well known because at the age of 89, she decided she was going to walk across the country to overhaul our nation's campaign finance system. So she set out from California. She didn't have a plan of how she was going to be housed, where she was going to get fed, how she was going to make it across the way. She just started to march. And people came out of their homes and marched with her. People fed her. People housed her. She cross-country skied through part of the country. She was determined to make it all the way to Washington, D.C., and she did. 14 months later, 3,200 miles later, turning 90 in the process, she made it to Washington. And when I heard the news that she had passed away, I had the honor of knowing her. When I heard the news that she had passed away, I thought about the fact that when she was born, the 19th Amendment, guaranteeing women the right to vote, had yet to be placed into the Constitution. She saw in her lifetime 9 amendments passed by the United States Congress and ratified by 3/4 of the states. We can do this. We have done it before. And in the name of Granny D, we must stand up and demand a 28th Amendment to the Constitution to reclaim our democracy and our First Amendment. Thank you very much.